Hi everyone, Harry here to talk about a really rich little two-page document that seems bland and ministerial, and then you take a second look and it reveals that the Department of Justice, in all its competence, sent Volume 2 of the Jack Smith Report, the very document they are treating with the assist of Judge Aileen Cannon in the Southern District of Florida, as the state secret of all state secrets, up there with the nuclear instructions, nobody ever to see. And they sent it by mistake to defense counsel. This is the lawyers in the Lindberger case. You may remember she worked in the government, and as she was leaving, she sent herself Volume 2, thought it might come in handy one way or another, had a little subject line of like bundt cake recipe or chocolate cake recipe, and was found out and is being prosecuted. A fairly strong case, really, even though the underlying point that Volume 2 is under wraps is really bogus. I'll get a little bit back to that in a moment. But anyway, the defense attorney one day gets discovery in the mail. Here's our discovery under Rule 16, which the government has to give. And lo and behold, the Holy Grail, Rosetta Stone, the actual Volume 2 of the Smith Report is there. Okay, this actually happens sometimes. I've never seen it with such a document that the DOJ, under the orders of the President of the United States, is turning cartwheels to preserve and keep out of the public eye. But it happens sometimes that in a kind of production of overall material, the government will send something that they shouldn't have. Every time I've seen it, and I've seen it, more than a few, it's because it was privileged. There was actually, oops, we sent you something that is privileged, and that can have actually very bad consequences for the defense attorney, result in being disqualified. But anyway, the Boy Scout thing to do, and the thing that this defense lawyer did do, is to look at it and put it aside and call up the prosecutor and say, hey, Bob, I think you maybe sent me stuff you didn't mean to. Here's what I'm talking about. Should I have that? And that's the, total stand-up officer of the court way to go about it. And then you try to unscramble the eggs and keep it from having adverse consequences for the defense attorney. So the guy does that, and the government now has filed a joint notice of inadvertent discovery disclosure. To whom? Aileen Cannon, because she is the one who entered the protective order in the Nauta and de Oliveira cases, which, remember, are completely extinguished. But she's saying because of their ongoing interest in reputation and whatever, we must keep this all under wraps. Nobody can see it. Quick aside is a number of senators, led by Senator Schiff, have sued a couple weeks ago, saying there's like nothing left to protect anymore. The cases are over. In the meantime, you're talking about a document of huge public import. It really is an overwhelming case for it to be disclosed. I suspect it will eventually, but maybe not by Aileen Cannon. But now we have it, and you have this very bland kind of two-page little discussion. Yes, we indicted, we did rule discovery, and defense counsel promptly notified the government that there were some documents that maybe they were not intended to be produced. Government confirmed that, and defense counsel voluntarily ceased review. I mean, that's really what you do, again, if you're a Boy Scout and it's a regular sort of say privileged document, you document that you're putting it away and sending it back and the whole thing. Here, they just say so. And the defense counsel said, as happens in these things, we haven't examined them any more than to see, oh shit, this is not what you wanted, and we deleted all of it, including with flash drives that had it. We did it right away. And the final word: the government acknowledges the professionalism and candor of defense counsel in remedying this inadvertent inclusion in discovery materials furnished by the government. Full stop. So not a word about, oh man, are we morons here? And of course, this goes to Eileen Cannon, right? So they needn't worry. She will say, very good, I recognize it. Maybe she brings in the defense attorney to question them and say, okay, you've destroyed everything. Do you have an affidavit, officer of the court? Because I've ordered that this can't be disclosed, and the inadvertent discovery doesn't change anything. We've had other cases of where things have been sent to the defendants, but they haven't been inadvertently produced, but just part and parcel of obligations in that case. Here it's just, oops, did we mess up? And, it will just kind of stay antiseptic like this. Cannon will just make sure everything's okay, except now we have this public record of the Keystone Cop government that really can't shoot straight and just turned over the supposed keys to the kingdom, which I've said before, Eileen Cannon will fight and fight some more, but it may be hard to predict exactly the legal route it will go, though I expect it will proceed to the Court of Appeals for the 11th Circuit before justice is done. And it's fundamental justice that this document belongs to the people, not to co-defendants of Trump whose cases have been dismissed. One way or another, I think it's going to be coming out, but not here. This is, when a defense attorney swears as an officer of the court, you've deleted everything. As I say, I've been involved in these things. They do. It would be a really astonishing transgression to, at this point, be lying to the court. So they've cleaned up this little nuclear waste this time for the government, but it really drives home both the kind of hypocrisy and the, let's say, absence of due care on the part of the government that, has been protected at every turn and will be for a few more turns, but not infinite number of turns by Judge Cannon. So this will just kind of go cleanly, antiseptically, etc. But it brings home in the broader public sphere. Yeah, what about Volume 2 and the lawsuit by many senators to force Cannon, maybe by order of the 11th Circuit, to produce this damn thing? One way or another, Trump's and Cannon's and Nauta's and de Oliveira's concerted effort to just erase this from the pages of history, I'm here to tell you, is not going to work at the end of the day. Talk to you later. Thanks for watching Talking Feds. If you enjoyed this video, please remember to like and subscribe. And for a lot more content, all of my essays, ad-free podcasts, and weekly Ask Me Anything Q&A sessions, check out the Talking Feds Substack and please subscribe there as well. Talk to you later.
Thanks very much. Mr. Clark, are you aware that they FBI executed a search warrant with respect to the Fulton County election records and seized a considerable number of records.
I'm aware from the news, yes.
Did you have any contact with any person within the Department of Justice or the FBI relevant to that search warrant application or that search?
No, during that time period, if I'm remembering correctly, I was at OMB.
No one reached out to you?
No one reached out to me.
How about the witnesses that were in the search warrant application? Did any of them have any contact with you related to that search warrant application or that search?
I don't know who the witnesses are, but to my knowledge, no.
Let's go back to your Georgia letter when you were in the Department of Justice. As I understand it, you had been in the Environment and Natural Resources Division, which has no authority over elections. You had been acting chief of the Civil Division as people cleared out at the end of the Trump administration, again with no role in elections.
Incorrect.
And as
Senator.
best I can tell, you had no prior experience in elections law. Is that correct?
Also incorrect. So both things are incorrect. I ran the two divisions, the Environment Division and the Civil Division, total of 1,400 lawyers simultaneously. And the Civil Division did have several election cases. There are two major sets of them. One
Did you, and were you directly involved in any of those cases?
Yes. There's
And
one in particular I will tell you about, which
Well, that's
totally
okay.
goes
I'm
against-
asking the questions here, so let me continue. When you wrote that letter, who in the Civil Division did you contact with respect to its contents?
That is something that would be law enforcement privileged inside the Justice Department.
No, it's not.
It absolutely is, Senator. What lawyers I consulted and what they said and what I said to them, all of that is something
No,
that's
what lawyers
contained
you
within-
consulted, maybe what you said, but certainly what lawyers you consulted. I'm entitled
No.
to know if you bothered to consult a single lawyer in the Civil Rights Division before you did that. But I'll turn to a different question. Who from outside the Civil Rights Division or outside of the Department of Justice gave you advice about that letter?
In terms of that letter, again, anything related to how that letter was formulated is law enforcement privileged.
That just ain't so, and let me ask that the record include the Board of Professional Responsibility opinions with respect to throwing out Mr. Clark's claims, false claims of privilege. So let's just say that somebody from outside the department put you up to writing that letter and told you what they wanted in it. What privilege would that require?
Well, there, Senator, hopefully I can help you by assuring you that there was no one from outside the department who put me up to writing a letter. I'm quite capable of writing a letter, thinking about it, and making my own legal decisions.
No one contributed text to you? No one contributed ideas to you? No entity or person asked you to do this?
Again, these kinds of things would be part of privilege.
No, they wouldn't. You're
would.
just wrong about that.
Well, you can say that, Senator, but I disagree with you, and I
I
don't
know,
what
but
you're
you've
gonna
asserted
refer-
privileges before, and you've been wrong. You assert privilege willy-nilly with no real basis for it. So, by the way,
I
it's not
disagree
even
with
conceded
that
that
recommendation.
those privileges matter in Congress. In fact, Chairman Grassley has repeatedly said that there are a number of privileges, and I think many of us agree with him, that simply don't pertain to congressional investigations because of the separation of powers. So what we're asking about here is whether you were put up to this by outside entities, whether those outside entities helped get you the meeting in the Oval Office with Representative Perry, who was behind that, and who was behind finding you a dark money-funded landing pad once the Department of Justice tenure was over and you were picked up by a dark money-funded advocacy group. Those are legitimate questions. I intend to pursue them. My time has expired. Thanks very much, Mr. Chairman. I'd like to take the time we have here to raise an unrelated issue. You can relax.
Thank you.
We, as a committee, considered the nomination of an individual named Emil Bovee to go on to the Third Circuit Court of Appeals. At the time that we did so, there was a pending proceeding in federal court, an inquiry into whether Mr. Bovee and others had committed contempt of court. That proceeding was stayed by an order by two Trump appointees on the D.C. Circuit. They used a device called an administrative stay, which I think lawyers